try to share.
So, very good evening, friends. Today we'll be having the guidance from Advocate Denson Joseph ji, who is a practicing advocate, practicing in Chandigarh High Court and Delhi High Court. Basically, he is from Faridabad. We met him in college days while doing law. Earlier, he was basically running an NGO and was helping various people through his NGOs. But after passing the law examination, he is into full-time practice as an advocate, and he has been pursuing cases on humanitarian basis also. Like some of the cases pertain to road accident cases because of bad conditions of roads, and he was successful in so many cases. So it's over to Advocate Denson Joseph ji. Today's topic is Indian Evidence Act 1872. Although this is not in the syllabus, but it is a very important topic because we come across as an insolvency professional various documents and information as an insolvency professional. So how to appreciate such evidence, how to retain such evidence, how to create such evidence is very important. And to have a knowledge of the same, we must know the various intricacies and the provisions of Indian Evidence Act. So for this, Advocate Denson Joseph ji is amongst us. So please, sir, it's all yours now.
All right. Good evening to all of you. I hope I'm audible to all.
Yes, sir. Yes, sir. You
I'm
are
audible?
audible. Yes, sir. And your PPT is also is
excellent. Excellent. So I am thankful to Gupta ji for inviting me here, although I'm always pressed with time and I'm, practicing in 21 courts as of today. So that leaves me with very little time, but I revere and respect Gupta ji so much that we cannot deny Gupta ji every time. We have to accommodate in somewhere. So that is the reason and how this particular session has taken shape. Now, having said this, I have put together a very brief session. I told Gupta ji that I will take a session for 40 minutes, 45 minutes, and that is what we are trying to do. And just I also asked him this morning, what is the profile of people who are going to attend my session? So he very rightly told me that it will be largely enlightened CAs and company secretaries who will be attending, and probably insolvency resolution professionals or would be insolvency resolution professionals going forward. Having said this, it is my prerogative to focus my today's lecture largely on that aspect, so that because all this insolvency practice, as we look forward to or we plan to get into, is largely a practice of documents. So I will come to that, but after a brief introduction of what the Indian Evidence Act or evidence is. Now, just to start with a brief introduction, everybody would know that evidence is the eyes and ears of the court, right? It is a misnomer or a misunderstanding among the public that probably if somebody goes and makes some averments in the court will close its eyes and ears and immediately believe that person and probably hang the other person who is being accused of something, right? That is not how it is, and that is the whole purpose of Evidence Act, to standardize uh, how an evidence is to be appreciated, what will be appreciated and what will not be appreciated. So that is the whole code of Indian Evidence Act. Now, to go a bit further, where does this word evidence come from? The evidence comes from the Latin word called evidere, which means to show clearly, to discover clearly, or to ascertain or to prove. So there is no court who who will go ahead and straight away believe either party who is coming to it with one sort of accusation or an issue at hand which which one of the litigant wants to resolve. I would say that in one of the sessions where I was there to argue a matter in a sessions court, the court said that देखो जी, मुझे तो ये पता है कि मेरे सामने तो कोई भी सच नहीं बोलता, ये तो मुझे ascertain करना है based on documents or proofs put before me, who is telling the truth and how much. So therefore the evidence becomes of paramount importance that if you want to win your case or to prove a point, every evidence that you bring forth before the court needs to be believable, or has to have that convincing the convincing ratio good enough to basically make the court decide in your favor, right? So that is what the whole purpose of this session, as well as the Evidence Act, or understanding how the evidence works. Now, what are the kinds of evidence that we normally come across? So there are two kinds of evidences, of course. There is the written evidence and there is the unwritten evidence. So that those are the broad categories of evidence that we have. So when we talk about the written evidence, we talk about documents, which would include digital and electronic documents, which means data stored on digital copies, pen drives, CDs, etc. And then you have the other documents, documents which record words in printed form, or in a photograph form, or in lithograph form. Then you also have uh, the a map or a plan, for example, a sanctioned plan of a particular project, or a map of a particular place. All of these are considered to be written documents. An inscription on a metal plate is, or stone, is also considered to be a document, although it would largely relate more with the unwritten tangible object stuff. But then still, an inscription on a metal plate or a stone is considered to be a written document. Now, then comes caricature. So I believe everybody knows what is a caricature. A model, uh, a caricature is a model. So a model of a particular person or an object. So that caricature is also considered to be a document. Then I have already discussed that electronic documents or digital documents have been included as documents with the evolution of the technology, or the developments, or digitization of the world in general, right? So I believe that is clear, and I'm not going very fast, I believe. Guptaji, is it okay?
Yes, sir. It is okay.
Okay, okay. So now comes the unwritten part. So what is the unwritten part? We normally have the unwritten part as the oral testimony, which a witness comes to the court and delivers to the court, right? Where the opposite counsel gets the opportunity also to cross-examine the witness. So that is what is called oral testimony. Mind it, oral testimony just given by one side is not considered to be admissible until and unless that oral witness is cross-examined, right? So that is a very important aspect of the practice of evidence, or the jurisprudence of evidence. Now comes the tangible object. So when you would have seen that people, I mean, the police, for example, in a particular offense, produces the confiscated stuff, in if it is a narcotic stuff, or in case of murder, the murder weapon. So all of these objects or products which are confiscated or recovered by the police, they are all termed as tangible objects, right? So that is to basically broadly classify that we are dealing in our daily practice, as you go forward, with two kinds of evidences, which is written and unwritten form. Now, how is a written form, a written evidence submitted in the court is important to understand. So what we normally do is, there are two ways. I'll be skipping a slide, and I'll come back to the next one. So when we talk about the admitting or submitting a written document in the court, what we normally do is, we normally stamp that particular document as a true copy. So the stamps could be of either type, which you see on your left or the right. So what I would normally do if I'm to submit a document in the court is, I would take a photocopy of that document, and I will stamp it as true copy of the original. And then I'll put my signatures there, and then I will submit it to the court. So that is how the court admits that particular document. But when I say admit the document, it is limited to the tendering process. So I'm tendering the document to the court. It is not admitted as a evidence as yet. It will be admitted as an evidence only when the court either says that, okay, it stands proved, or I have proven it in the court going forward, or during the process of litigation, or in the process of or in the process as the court hearings proceed or progress. Okay, so that is how we tender a document. See, these are nitty-gritties what we normally come to learn only when we actually get into the real practice. Otherwise, we never are able to know how can I actually put a document, and we waste a lot of time learning and going around in courts, how to actually tender a simple document in the court. Now, I have brought up this small little slide, particularly with the insolvency professionals in mind. What happens is that I will begin with an example. I was actually defending a criminal case in Saket court, and what happened was the bankers who were actually the bankers of my client, who I was defending. I mean, the accused. The they produced a whole bunch of documents, of thousands of pages of documents, which included loan statements, the credit limit statements, the bank account statements of my client. Now, all of this was tendered because they were produced as prosecution witnesses by the prosecution. Now, once these documents were tendered, they were basically largely, I would say, bunch of reams and reams of documents photocopied from the banking records and banking files. They were tendered to the court, and the prosecution took it, and then they make markings, like, for example, if it is of prosecution witness one, so we make markings on those documents as PW1 oblique exhibit A. That is how we do it, right? So each document is marked if it is produced by, if there are, let's say, 3 documents produced by a prosecution witness, then we would say the short form for prosecution witness is PW, right? So we'll say PW1 oblique A for the first document. The other document would be marked as exhibit PW1 oblique B, and third would be marked as PW1 oblique C. So that is how we actually mark these documents. Now, this was marked as such, as I told, as I just narrated here, and then the proceedings went on. So we had other witnesses coming. Then I would cross examine them, and eventually we went forward. But when it came to the stage of actual arguments, the prosecution wanted to rely on this document. I objected to it, and the court asked me why. So these being banking documents, it is very important that this is one act which most of us neglect or do not know about. And that act is called Bankers Book Evidence Act of 1891, which has to be read together with the Indian Evidence Act 1872. So this Bankers Book Evidence Act 1891 particularly relates to all evidences that are produced by the bankers, or documents produced by a banking institution. Now, two important sections of this particular Bankers Book Evidence Act is, one is section 2.8, which talks about the certified copy. Certified. So what is a certified copy? It largely defines. So when I say 2.8, it is section 2 subsection 8 or clause 8, right? So it talks about certified copy. So it says that what is a certified copy? So now to narrate that, how it is defined. So section 2.8 defines a certified copy as a document which is a photocopy of an original document in the banking records, which is endorsed as true copy, which I showed before. I showed the stamp of true copy here. So it is endorsed with the true copy stamp there at the bottom of that particular document, right? So if it is done, then that becomes a certified copy, is what section 2.8 says. But then it goes on further, and there are 3 subsections again under subsection 8. There are clauses A, B, and C. Each of these clauses says that these certified copies need to basically comply with the provisions under section 2A of the Act. Now, what is 2A of the Act? 2A of the Act says that these documents, which have been endorsed as true copy at the bottom, need to be accompanied with 2 important certificates. And those 2 important certificates are a certificate issued by none else than the branch manager, or if not the branch manager, then the principal accountant. That is very important. It is not in the slide, but it is the branch manager or the principal accountant. And second, the person who has produced the printout. So the person who's in charge of that particular computer system, if any of the documents, whether it be voluminous or not, is not accompanied by these two certificates, then it becomes inadmissible as evidence in the court of law. And just because of that, I was able to object as also rule out all the evidences which were produced by the bank against my client in that particular case. So that is how relevant and how important this is. And this was a vague mistake by the prosecution's the prosecution, and they eventually suffered because they could not actually let their plans flourish against my client. So therefore, it is very important to have a look at this Bankers Book Evidence Act, particularly if you are interested in going ahead with the becoming an insolvency resolution professional, because every now and then you will be dealing with a lot of documents. You will be dealing with a lot of documents being produced by the bank as well, right? So now I move on to the next slide, which talks about what are the kinds of evidences.
But Joseph
Yes,
Ji, I have a question here. Can I ask now?
please.
So how to rebut this evidence? Suppose we object that, okay, this is not a certified copy, and whether they can produce the certified copy again. So
No, acha, okay, complete your question.
yes. So my question is, suppose the rival advocate or the learned
Yeah,
advocate sitting on the other side, he objected
yeah,
that, okay, these are not the certified copies. So
correct.
the banker say, okay, I'll reproduce it again next time, certified copies. Then where does it stand? Or
Okay, so now,
what should be the stage where the objection should be made, at the last
all
stage or
right.
what? Yes.
So the point is, yes, I mean, I think you said it just now, that
Yes.
when to make the objection, that is
Yeah.
very critical,
Yes.
right?
Yes. Yes.
That is the
Yes.
strategy in a criminal case,
Yes. Very
particularly in a
true.
criminal case. It's very
Ah.
important that
Yes.
you let the evidences be furnished initially. What
Ah.
happens is, now I come on to a little, I will deviate a little into the criminal procedure code.
Okay.
What happens is, at the time of filing of the evidences, there is a stage that, okay, each witness is called, each witness is filing his set of evidences, his that witness is particularly cross-examined, and his evidence is closed. Correct. So eventually, prosecution witness 1, 2, 3, 4, and at the end of so maybe the banker is the second one. You don't object to it. Simply ask some
Okay.
menial questions when the banker is being cross-examined. Okay, what is
Yes.
the
Yes.
what is the document? He would say these are banking records. You say,
Let
okay,
it.
these are banking records.
So you mean to say, let him cross the red light, then we will catch him.
Yes. You need to do exactly what our cops are good at. They
Yes.
hide themselves under the bushes
Yes. Yes.
and
Yes.
let the person and let the other person cross the stop line, and then you
Uh,
catch him. So
yes.
that is what happens. So eventually, just for you to understand the process, once all the evidences have been done and they have been cross-examined, what happens is that there is a stage in every case where the prosecution comes and says, or the court asks, are you done with your evidences? The prosecution says, yes, I'm done with my evidences. You say, okay, you go ahead and close the evidence. So they go and categorically make a statement in the court that, okay, I have closed my evidence today, right? Now, what happens is you now talk to them at the time of the arguments. Now they cannot go back and take a U-turn and say, okay, I'm coming back with a certificate to prove that these are certified copies, right? So that is the stop line that you need to wait for when the prosecution closes its evidence. And once that is done, you have your game all laid out well for you to play and score the goal, right? So that is what it is all about. So it is a lot of strategy that we, always keep on, unfurling all the time in the courts going forward. So now let me go to the next slide, which I was talking about, primary and secondary evidence. Now here, what we're talking about is what is a primary evidence and what is a secondary evidence. I think most of you might have an inkling of what is primary and secondary, but generally for you to understand it a little better, any document that is an original document, right? Original contract, for example, or original deed, for example, is a primary document for that matter. Now, what is so then just a little clearer understanding would happen. For example, there is a pamphlet that you're printing. For example, Gupta ji is printing a pamphlet that he is going to start an insolvency class from the month of December with some scheme. So if there are hundreds of pamphlets being printed by the same machine, all of them are original documents, right? They've Because there is a multiple print coming out from the same machine through the same mechanical process. It is not a photocopy, right? So multiple prints from the primary source becomes an original document. However, multiple copies of the original print are become a secondary document or a secondary evidence. Correct? So the section that deals with the primary evidence is section 62 of the Indian Evidence Act, and the section that deals with the secondary evidence is section 63 of the Indian Evidence Act. Right. Now, when we talk about secondary evidence, it is important to understand what is the secondary evidence. So any copy, we spoke about certified copies a while back. So any certified copy is a secondary document. And the interesting part is the third one, which I've hyphenated there. The other one, you can understand anything from a photocopy machine is also a secondary evidence only. But the third one is the most interesting. If I come and stand in the court and say and narrate a document, for example, I saw the sale deed bearing Vasika number so and bearing so and so date, executed at so and so place, is also a secondary evidence of that particular document. Right now, so now that it is clear, anything that is original is primary, anything that is a reproduction of the original is secondary evidence. I believe that is clear, right? So I will move to the next one. So first was the primary and the secondary evidence. Now we come across a classification called public and private document, right? Now, what is a public document and what is a private document? Now, this slide is very interesting in the sense, although it looks like just a plain slide. First topic deals with the public document. Now, what is a public document? A public document is defined in section 74 of the Indian Evidence Act, which says very clearly that any document which is which forms or which records an act or a record of an act, right? Which is a record of an act or an act which is published by the government. Let's say a gazette notification for that matter is a public document, right? And that is issued by the sovereign authority, let's say the government of India or the government of Haryana or the government of Delhi and city of Delhi. So all those are public documents. Then documents of acts of basically all the official bodies, tribunals, quasi judicial bodies that we have, which determine or adjudicate various issues that we that come to them on a day-to-day basis. So all of these are public documents, and they are but this particular let's say clause 1 of section 74 deals with only the acts and the records of the act, so which has also the gazette notifications, as I said. Now this clause second, so 74(2) of the Indian Evidence Act talks about public records of private documents. Now, what is a public record of a private document? That is what needs to be understood. So, for example, you executed a sale deed. Now, sale deed is actually a private document. It is a deed between two private parties, A and B, right? But then, because it was executed in the tehsil will keep a record in the SDM office or the tehsildar's office, right? Now, that record of that private document becomes a public record. Or there is a transfer deed that is executed between a blood relation, A and B, a mother to a daughter. So that document is also saved in the public records, and that also becomes a public document. So tomorrow, if you have a case that comes up and you take a certified copy for it, so if you want a copy of that particular document or the transfer deed or the sale deed, you can just go with the Vasika number to the SDM office or the tehsildar's office and tell them that, okay, I need a copy of this document with an application if need be in written, or otherwise just the Vasika number, and you need to pay them the requisite fee. So they will actually issue you a certified copy. So it says certified copy of so and so. It is stamped by that particular good office of that particular government officer. Now, having said that, so those private documents which are maintained, so if I'm to conclude, it says those private documents which are maintained in the public records of the government or the government tertiary units is called a public document. Now we come to the next one. What is a private document? Now, private document is actually defined in section 75 of the Indian Evidence Act, right? Now, what is a private document? It is an interesting document. I remember a viva voce examination in our LLB, Gupta ji. So
Yes, sir.
the examiner asked me कि ये फौजदारी के केस कौन से होते हैं. So I very simply said, जो दीवानी के नहीं होते वो फौजदारी के होते हैं. So that is the kind of definition that is given here in section 75 for the private documents. It says whatever is not a public document is a private document, right?
So
There
there
is
is a
no further
question also
elaborate.
here. There is a question also
Yeah,
here. Certificate of
Yeah.
incorporation of a company,
Yes.
whether it is a public document of private document or what?
It is a public document
It is a
because
public, yes.
it
Because
is a
it is
public document
yes, yes, yes.
because you can get a record. You can get a record from the registrar of companies, right? At
Yes.
any time.
Hmm.
So but any document which you can get from the government becomes a public document, right? So sorry, public document, and because there is a public record of that private document. Clear?
Okay.
Now,
And basically,
I
it is
come,
issued by the registrar of companies, so it is a
correct,
public
correct. It
document.
is issued
Yes.
by, that is why
Ah,
it is a public document,
yes, yes,
right?
yes.
Had you issued an agreement to your friend of yours, then
Yes, yes.
that would not be a public document.
Yes.
Right.
Hmm.
So now, having said that, I come back a little to elaborate a little on the private document, a contract between two parties, right? A contract between two parties, even if it is executed on a 100 rupee stamp paper, it is a private document because there is no public record of that. The record will only be in your coffers. Either you will have a copy of that or the other party will have a copy of that in your company or in your office or or at your house. So that is what a private document is. So private document is largely a document executed between two parties which the government doesn't know of, or it only knows about to a limited extent, to the extent where it does not have to retain a record of that. Clear? So that is a private document. Now I come to another important section, though I could have skipped it, but it is very important because you would be tomorrow dealing as insolvency professionals, is what I believe. And therefore you would be dealing with a lot of documents. And this particular, I mean, you may be called upon to, testify upon a document or as a witness in a court. So in that case, you need to know about this section. Now, why is this section very important? I will narrate it through a small incident. I was arguing a civil matter against a very branded, I say branded civil lawyer. Reason being, the fact that he had a name or an experience of about 25-30 years of experience in civil practice. Now, when we were arguing the matter, when it came to the final arguments, we went through the entire process, litigation process of filing our pleadings, and then we, so just to give a narration of what happens in the courts. There is a pleading filed by a plaint filed by a party A. Then there is a written statement filed by the defendant, party B. And then, once the written statement has been filed, then what happens is there might be a rejoinder that the plaintiff will file. And if there is no rejoinder, the court places it for evidence. So it says that, okay, from the next or then on the next date, we will start the evidentiary process. So the plaintiff, it starts with this, the evidentiary process will start with the plaintiff recording his evidences. In civil cases, so when I say civil cases, a majority of your insolvency practice is also civil, right? So when you talk about civil cases, evidences are always furnished in the form of affidavits. That is very important to know, right? Your evidences have to be filed in the form of affidavits. So when you say affidavit, so it is an affidavit where you say that I, so-and-so person, son of so-and-so, resident of so-and-so place, presently in Delhi, for example, hereby solemnly affirm and state that. So you will state what are the facts that you want to affirm. Now that becomes an evidence, and you will say that I'm producing a document A in support of this claim. I'm producing a document B. So you will append all those documents with that affidavit, and that affidavit has to be endorsed by an oath commissioner. It is only then that you can tender this document. And when you go to the court, you cannot just go and throw it at the face of the reader and walk away. So what the court does is the court appoints a local commissioner. The local commissioner makes a record of that. He writes a document. He makes a document himself with his own hand, and that document he will write A, first of all, he will give the title of the case A versus B. Then he will say on solemn. So we write on the right hand side, we write ONSA, which means on solemn affirmation or affirmation. And then, he will record the statement of, let's say, the plaintiff A. Let's call it plaintiff A. So he will record that so and so, I am so and so person, son of so and so, presiding in so and so, and I hereby solemnly affirm that I am tendering my affidavit of evidence today on in this court before so and so at so and so time. And then he will sign at the bottom of that paper, read and checked. So we write it RO and AC. Okay, read over and checked. So that is RO and AC. And then the affidavit that you've tendered is attached to that particular cover sheet which has been prepared by the local commissioner, and it is only then that is it is tendered into the tendered before the court. That is when it becomes admissible as an evidence before the court. And then on a later date, you will be cross-examined. The person who is filing that evidence will be cross-examined. So that is the process for you to generally understand how it works in the court, how a tendering of a document works in the court. Now I come back to section 77, which I had started off with. What is section 77? Section 77 says proof of documents by production of certified copies. So the incident that I was talking about, where I was arguing against a very senior civil lawyer who was 25 to 30 years into civil practice, he suddenly, at the time of arguments, because I was arguing a particular matter about the ownership of a particular property, which was transferred by a mother into the name of the daughter, and it was transferred, it being a blood relation, it was transferred by way of a transfer deed in a blood relationship. Now, because I had put a certified copy there, I had adduced evidence through a certified copy of that particular document of transfer, the counsel, the advocate on the other side, objected very vociferously, saying that this document cannot be taken. He did the same thing, he waited for me to close the evidence, and at the time of the argument, he objected to it that this copy cannot be admitted as evidence or admitted in evidence. So he said that, okay, this copy being a certified copy cannot be admitted. So I was prepared for such an argument, and I immediately said, I'm sorry, my learned friend is wrong here, because section 77 allows me to provide certified copies of documents which are public documents. And the moment I said this, the judge said, Vakil sahab, jara wo section batana, aap kaun sa bol rahe ho? Then I had also an extract with me of section 77 of the Indian Evidence Act. I gave it to the court, and eventually the court was also convinced. Court allowed the evidence, and eventually won the matter. Right. So it is very important to know, when you are producing a document as a certified document in the court, you must also know under what provision you are providing it. Otherwise, there might be instances where other person who, just because he's smarter in presenting his case, he might get away with that. So that is why it is important, and why I'm explaining this section 77, which is very important for all of you who particularly are aiming at becoming an insolvency professional tomorrow. Now I come back to the last section on my slide, which is section 79. Now, this is section 79 in the Indian Evidence Act, largely deals with the presumptions. Now, what is the presumption that the Indian Evidence Act has in respect of certified copies? So what it says is, so what I mean to say is that this section particularly talks about whether the court would presume or not the genuineness of the certified copies that you produced, right? So if I were to recollect what is mentioned in section 79, it particularly says that the court shall presume. It says court shall presume. So any certified copy that you have produced in the court automatically presumes that this is a copy of an original document which actually is in existence somewhere in the public records. Correct? So that is what that is what this presumption is. So this presumption always helps you. So it is always read with section 77. So whenever you are making an argument, under the provision of section 79, so you can always say this is to be read with section 79, where there is a presumption which weighs in my favor, right? So that is to sum up how the public and private documents actually work and move in the court. Now, another last section which I would like to cover for today. I mean, I could go on for another, I could have 4 or 5 other sessions, but another very important section which I cannot let go before we close this session today is section 65B. I believe everybody knows what is you would have been hearing about section 65B. Section 65B has become of paramount importance these days, because whenever we are producing or adducing evidence in the form of electronic documents. Now, what is an electronic document? Somebody can. I don't have a slide on 65B, so I'll be speaking off it. So I'm sorry about that. So, so what 65B largely talks about is, um, Gupta ji, I can put on my video.
What?
Is my video on? I don't know. Okay,
Definitely. Yes, definitely.
I don't know if I can.
You
I can.
you are a co-host, yes.
Acha, okay, okay.
Yes, yes, yes.
So the point is, the 65B is why I put on the videos, because this is my last slide. Oh, sorry, last segment. So I thought, let me put on my video. So 65B largely speaks about, uh, how to adduce your electronic evidence, in the courts. So what happens is, just a moment, just give me a minute. So what happens is, in the courts, when we are producing a copy of an email, for example, or there are instances where you are producing audio, audio of a particular discourse between two persons, where one person is saying something, the other person is saying something, or one person may be threatening the other person to saying that he would do this or do that to that other person, or it could be a chat, message chat, right? I'll come to the WhatsApp a little later, but I'll come to the other chats. There would be a SMS which is exchanged between you and Bisleri, for example, or you ordered something and you had a message coming in from Blinkit or Grofers, for that matter. So how does that work? So all of these what you do is, normally you take printouts of these chats or emails. Now, if you file these as it is in the court will not consider it to be an admissible evidence. So what do you do about it? So what you have to do is, you have to actually frame or draft a certificate under section 65B of the Evidence Act. Now, what does section 65? What does section 65B say? So it is more like an affidavit, right? I just, a little earlier, I said how an affidavit is to be worded. So it will also say, I so and so person, son of so and so, residing at so and so place, aged so and so, hereby solemnly affirm and state that. So that is the opening para that you will say. And then so it will be headed as 65B certificate. You can give the title of the case, for example, A versus B, certificate under section 65B of the Evidence Act. And then as I said, I so and so person residing in so and so person, at so and so place, and then you will narrate the instances of what this document is. So for example, if it is an email, I would say that this email is an email which has been printed out from my, an email which was received in my inbox in my normal day-to-day work. Then second thing that you will have to certify is that you took a printout of this email, through your laptop, wherein you through your laptop, where you have to give the nomenclature of that laptop, the model. For example, if you are, for example, I am using, for example, the Lenovo pad, for example. So I will say I'm using Lenovo pad so and so, let's say, or Asus X515, the model number with the configuration, and there is a serial number there at the back of your laptop. So you have to give the serial number of that particular laptop. And then you have to say, I took a printout. This printout has been taken from my printer, which is in my office, and it is in a running condition. It's very important that you mention that. And then you have to give the model. For example, I use Brother FXD, for example. So I would write, I took a printout which is fully operational, and it is operational on a day-to-day basis, and it is in regular use, and the model number is so and so, and I will give the serial number of this particular, the make and serial number of this particular printer also. So once this is done, then you will actually say that, okay, this printout was taken on so and so, and it is being it has not been circulated anywhere else, and I'm producing it for the court for to be adduced as evidence in so and so matter, right? So 65B, unless and until you furnish this certificate, no piece of electronic evidence, whether audio, video, or email will be accepted by the court. So it is mandatory that any email that you're producing. So why I'm stressing on the email part is there are lots of emails that we exchange between parties, and these become the subject matter of uh, you know uh, of our evidence when we are actually arguing a matter in the court. And therefore 65B is of paramount importance, and you need to ensure that every evidence of yours is accompanied by a 65B certificate. Now these evidences, now we spoke a little earlier about primary and secondary evidences. So when you attach a 65B certificate to a copy of the email that you produced or printed out from your printer, it becomes a primary evidence. Okay. Now, so any document that you have produced, whether it be audio, video, because it is an audio which you recorded, it is an audio which you have, or a video that you have recorded with your camera or your mobile phone, then that becomes a primary evidence, provided it is furnished along with a 65B certificate. However, in case of WhatsApp, earlier on, the courts were not admitting chats on WhatsApp as evidence which could be considered for prosecuting somebody. However, of late, after a recent Supreme Court judgment, what has happened is WhatsApp chats are also being accepted or tendered as evidences, but they are, along with 65B certificate, of course, but they are considered to be only secondary evidences. And that is largely because of the encryption that WhatsApp still enjoys, and it protects its data with. So the original data is actually with WhatsApp. It is not accessible to even any government across the globe, and therefore it will remain a secondary evidence, and it will have only a corroborative. I won't say that the prosecution can hang somebody with something, an evidence which is adduced as a WhatsApp chat, but it will certainly help to corroborate some stand that you're trying to take in the court with along with other sets of evidences that you might have adduced. So that is the stand of that is the what do you call the annual at which the WhatsApp will qualify as a evidence, or as an evidence before any court of law, as far as WhatsApp is concerned. So as far as today's session is concerned, these are the topics I intended to cover. I believe Gupta ji have done justice, and probably you give me another opportunity, so I will have a more detailed session on various other sections which could help insolvency professionals as well, and we could look forward to learning much more and enlightening your students or learned fellows much more than what I've done today.
Thank you very much, Advocate Jensen Joseph ji. It was really an enlightening session, and I hope all the insolvency professionals who are attending, or the intending insolvency professionals who are there, must have gained an insight into the various provisions of Indian Evidence Act. Now it is an open house for you can ask any question to the learned advocate. It is open for just 5 minutes. You can just raise your hand so that I can unmute you. So T.S. Siva Prasad ji, you want to ask something? So you can unmute yourself now.
नहीं.
Okay. Oh, no, sure. Okay.
नहीं, ये एक सवाल है.
Yes,
So
sir.
how can we use this act and to in the practice of our profession as an IP?
I think you joined late. He told us in detail okay, what type of evidences are admissible in the court, how to produce an evidence, and whether or not a court will admit an evidence, and what are the various sources from which these evidences are available. So he dealt at length for the last 45 minutes on the various types of documentations. If you have any specific question, then you can ask.
नहीं, और इसके अलावा कुछ नहीं.
Okay. So Chattopadhyay ji is having a question. Chattopadhyay ji, just a minute. Chattopadhyay ji, now you can unmute yourself. Yes, we will share the PPT, and this session was being recorded also, and it is
very good session, sir.
And it is live on Facebook also. So a lot of people are watching on Facebook as well.
Okay, sir.
जोसेफ जी बहुत बहुत धन्यवाद.
Thank you so much. Thank you so much.
So thank you very much, Advocate Jensen Joseph Ji. It was
Thank you,
really
Gupta ji.
wonderful session, and we'll look forward to more such sessions in the future.
Certainly will join
Anjay.
hands.
Anjay.
Thank you. Bye-bye.
And I'll
Bye-bye.
request you to give us a copy of the Bankers Evidence Act in PDF format on my WhatsApp.
I'll do that. I'll do that.
Okay. And a copy of this Indian Evidence Act also, so that I can share it in the group.
I'll do that. I'll do that.
Anjay. Thank you, Ji. Thank you so much.
All right.
Thank you, Ji.
Bye-bye. Take care.
Thank you.
Good
Thank
day,
you.
bye.
Oh, okay, Ji. Okay.